Welcome everyone to the first PLX webinar of the academic year. And it's great to start the year with such an historic victory for the climate litigation movement and field. As many of you know, PLX, the Climate Law Accelerator at NYU Law School, organizes a monthly webinar where we discuss a cutting-edge case or a report or some sort of promising idea that hopefully pushes forward the frontiers of climate litigation to accelerate and scale up climate action through the creative use of law and litigation. And again, we cannot think of a better example of all of that than the Hell versus Montana case, which this is why we call it in the title for this webinar, the announcements, a turning point for youth-led climate litigation. As at CLX, this case and this victory has a special meaning for two reasons. We spend a lot of time working with practitioners. We ourselves conduct some litigation in collaboration with litigators from around the world. And of our children's trust has inspired us from the very beginning. In fact, in some of the cases that we either undertaken or supported in Latin America, the president of Juliana, the whole series of cases that OCT has led in the US for 12 years now, was definitely one of the foundational inspirations and sources of energy and ideas. So we're grateful to OCT and to everyone who's contributed to that hard work. And also, we are based in a research institution here at NYU School of Law. And in our own research, we're finalizing a book-length history of the climate law and litigation field. And in talking to some of the key kind of protagonists of those early years in the early 2000s up to the mid-2010s, it's clear that climate litigation, especially this type of case brought before to courts by young people, was seen as improbable, to say the least. In talking to one of the interviewees, they said that OCT's litigation was received with one of three responses. Some people, a few people, especially in the advocacy field, thought that it was a great idea to sue states or federal at the federal or state level for not doing enough about climate change. Then other people thought it was impossible, and this is actually the reception I saw even in other places of the world, where even sympathetic viewers and observers thought that this type of case was very improbable to the even impossible. And then there were people who thought that they were reckless, that they were counterproductive. And what's interesting to see over the years is that people who used to say that these cases were reckless are now saying that they're great, which is an indicator of success. We will take those conversions and those shifts of mind as signs that there's something that's being done well. And the organizations like OCT, who patiently and stubbornly and very courageously kept at this, despite the various responses and despite the slow pace of change, and to be able to feature this historic win here for us is a special occasion. So with that, let me go to our conversation today. As you all know, we shifted at CLX from a panel-based format to a more conversational approach. And today we have a professional trial lawyer, so I don't think that we'll have any problem with a conversation with this particular interlocutor. But we're glad to see that this calendar year, our participants, the quote-unquote audience, has felt more comfortable typing questions in the Q&A box and also coming into the conversation more decisively after, we'll spend about 20 minutes on that Q&A segment, but by all means, this is not meant to be kind of a presentation, but more of a conversation initially between Phil and me, but then among all of us. Now on to today's conversation. Today, we're grateful to be joined by Phil Gregory to delve into this important case. Phil has served for the past 10 years as sub-counsel of OCT on a pro bono basis, all while maintaining his litigation practice with the Gregory Law Group. Among his work for Our Children's Trust, Phil served as co-lead counsel in Juliana versus United States and co-lead trial counsel in Health versus Montana. For Health was in the room where it happened for the purposes of developing every aspect of the legal and trial strategy. He defended and took the pre-trial depositions of numerous youth plaintiffs and expert witnesses. At the trial in Hill, as some of you may have seen in the video streaming, Phil examined 5 of plaintiffs' experts and cross-examined defendants' sole expert witness. Phil is also a fellow with the International Academy of Trial Lawyers and a member with the American Board of Trial Advocates. So Phil, thanks so much for making time to join us today. And I want to start with a basic question so that we're all on the same page. For those who are not familiar with the details of the case, could you briefly explain what this case is about and what the judge ruled in the decision handed down in August?
Sure. And before I start, I just want to say that the work you're doing, as you well know, is so vital and complementary to the work we do that I just can't let that go unsaid. But let's talk about Held. So way back in 2020, we filed the complaint in Held. And a quick story on how that came to be about. Nate Bellinger, the key attorney behind the complaint in Held, was going to drive to the Helena, Montana, file the complaint with all the plaintiffs standing around him. He drives there in middle of a snowstorm, a blizzard, and he finally gets to Helena, Montana, just on the day that the pandemic orders came down, March 13, 2020. So none of the plaintiffs could be there, and we were literally one of the last complaints ever filed in person in Helena before the pandemic broke. But the complaint in Held is in state court. The capital of Montana is Helena. It's on behalf of 16 youth plaintiffs, various ages, all the way up to 18. Ricky Held, at the time we filed the complaint, was 18. And we sued the state of Montana and the governor of Montana and specific state agencies over 2 statutes at the time. One was called the Montana Energy Policy Act, which essentially required state agencies to promote fossil fuels, to get fossil fuels out of the ground, et cetera. And then the equivalent of NEPA, it's MEPA in Montana. And in the Montana Act, what I'm going to call, there's called the climate change exception. And in 2011, the Montana legislature passed a statute that in essence said that state agencies cannot consider the effects of fossil fuels and emissions, et cetera, in permitting and related decisions. And all this is in the context of the Montana state constitution, which provides that the state shall, in essence, preserve and improve a clean and healthful environment for present and future generations. So you have the Montana Constitution on the one hand, you've got the 2 statutes on the other. And so the Held case was moving forward on the role of fossil fuels, both combustion, extraction, and transportation throughout Montana as what is going on in the state, because there were numerous permitting decisions being made without considering the impacts on the climate, without considering fossil fuel emissions. And then moving forward, just to give you context, I'll stop right when the trial's about to start, so you can ask me another question there. But in May, so we're going forward, and as I said, the climate change exception had kind of vague language about whether or not they could consider fossil fuel emissions, the state agencies. And in May 2023, so 1 month before the trial, the Montana legislature, in its infinite wisdom, passes what they called a clarification to that statute that said specifically the state shall not consider fossil fuel emissions, shall not consider the implications on the climate in approving projects like coal mining or fossil fuel based power plants. And the other key development that occurred is, remember, the other statute was the Montana Energy Policy Act, and the legislature essentially rescinded that act. So it was no longer a factor at the trial. So the trial focused on essentially the Montana constitutional provisions and the related provisions of equal protection and due process and the public trust doctrine in which our complaint was grounded, and the MEPA, the provision that said that the state shall not consider fossil fuel emissions and the resulting implications to the climate. And that is what occurred when we started the trial on June 12 of this year.
Thanks, Phil, for that very clear opening statement about the facts of the case. Now, moving on to the ruling. The ruling has been received enthusiastically in many quarters, but people have had different interpretations of the extent of the precedent. Some people say, well, this is a very carefully construed decision that applies to a particularly egregious effort by the legislature to tie the government's hand in looking at the climate impacts of fossil fuel infrastructure and fossil fuel projects. Other people have said, no, this is it's an important precedent that may be replicated in other states and may have broad repercussions. From your point of view, what are the main jurisprudential advancements and contributions and potential ways that this decision may be applied to other jurisdictions?
Sure, and I believe that the Held decision is historic, but I also believe in the powerful nature of the Held trial, because this was the first climate trial to occur in the United States. And we were able, in walking the judge through the various aspects of what we'll call climate litigation, to present the full picture. So we started, the trial was fascinating in that we started, our first witness was May Nan Ellingson. And the beauty of May Nan was back in 1972, Montana had its constitutional convention, resulting in the constitution that was the subject of the trial. And May Nan was the youngest delegate to that convention way back in 1972. And she was responsible for getting Montana's clean and healthful environment provision into the Constitution. So we started the trial with the constitutional context. And this is very important, particularly for students, to see how a trial moves forward. Because what we wanted to do was to educate our judge both about the climate effects of what were going on as a result of the clean and healthful environment, but more specifically, how those effects were impacting our youth plaintiffs. So the way we proceeded pretty much through the trial is we had, let's just call it an expert witness, and then we had a youth plaintiff. So after May Nan Ellingson, we had Ricky Held, who got up there and eloquently spoke about the effect of climate on herself, on her ranch. And then we moved to Dr. Steve Running, who explained generally how the climate is affected by fossil fuel emissions. And then we moved plaintiff, expert, plaintiff, expert. So like a symphony, we were trying to tie into each of the plaintiff impacts expert testimony that explained their significance. One thing I want to talk about before we get to the actual decision is we had testimony from Mr. Pete Erickson, and it kind of hasn't gotten a lot of publicity, but it was significant because what Pete talked about was, this is how much Montana's contribution is to the general climate crisis, to how many, what's its emissions, the state's contribution. And the reason this is important is three things. One, held, like all our cases, it's not about government inaction. It's not about government failing to protect. It's about government action, government permitting, government promoting, government focusing its attention on elevating, putting the accelerator to fossil fuels. And so Pete countered the state's defense that, hey, Montana doesn't matter. Pete showed that Montana accounts for annually 166 million tons by way of emissions, which is more than 100 countries. But the final point I want to make on Pete's testimony is what I think makes held extremely significant, in that Pete talked about not only what Montana has done, not only what Montana's doing, but Pete showed the judge all the fossil fuels that remain to be extracted, so that if the judge doesn't issue an order that what's going on is unconstitutional, all these fossil fuels are going to be extracted. They're going to have substantially greater impacts, not only to the young plaintiffs, but to future generations. And I think that testimony, along with the health testimony of Dr. Lori Byron and Dr. Lisa Van Susteren, how these plaintiffs are being affected physically, emotionally, mentally, really was compelling to Judge Seeley, and allowed her on August 14th. So the trial started on June 12 and ended 7 court days later with closing argument. And then on August 14, she issued her incredible decision. It's, if you print it out, which I have, it's remarkable, and I highly commend everybody to read her decision. But what she did is she exercised great judicial courage, because what her decision does is weave the evidence that we introduced. And again, for practitioners, it's all about the evidence. That you got to get that evidence into the record. We did, the state didn't. And as a result, Judge Seeley was presented with this a vast amount of evidence about how Montana is affecting the climate crisis through an actively promoting fossil fuel emissions. And she found that to be the statute that prevented the state from considering these emissions and the impacts on the climate crisis to be unconstitutional, because in doing a quick analysis, it was injury, the statute was causing injury to the plaintiffs through government action, and that the court could do something about it by requiring state agencies to no longer apply this statute, so that they could do what they were trained to do and had done before the statute, and that is consider the effects of fossil fuel emissions on the climate and on harms to the state of Montana. So her decision is historic, and it's we can talk more about the precedent of the decision, but I really believe that it's going to be remarkable going forward how many other courts rely on Judge Seeley's opinion to address the climate crisis.
Thanks, Phil. We'll definitely come back to the repercussions on other cases and how narrow or broad the holding of the ruling was, because we also have a couple of questions that point in that direction. But for now, let's stay with what you just said in terms of the interweaving of expert testimony and plaintiff's testimony. By the way, I see that Kelly Matheson is with us, who's the international director of OCT, but before becoming the international lead, she was already quite active in OCT and also in the CLX community. And she wrote a fantastic chapter for a book that we edited that focuses on storytelling and how storytelling is crucial. And when you were describing the interweaving and the interspersing of experts' views and young people's views, that sounded to me like a very powerful narrative strategy, in addition to being a powerful legal strategy. Now the piece, so that's highly original. Now other observers have said that this is the first time that climate science was on trial, and that it's the first time that expert witnesses from the scientific community were there being examined and cross-examined. Other cases, of course, have drawn on climate science. But what would you add in terms of the importance of bringing experts to trial hearings and to working with them? I imagine that this took many months and even years. And since this is an audience made up of practitioners and scholars, what would you say, in addition to what you said about working with experts and bringing in that piece to the court?
The experts in this case, all of them worked pro bono. All of them worked for free. And each of them spent hundreds of hours first preparing the expert report, then preparing for and sitting for deposition, then helping us prepare for their trial testimony, particularly the demonstrative slides to show Judge Seeley the point they were trying to make. And finally, for testifying at trial. It was an incredible effort by each of our experts, and I want to just compliment them on that. Now let's talk about the expert testimony. What we tried to do is make sure that each aspect of the climate science, not only globally through Dr. Steve Running, but specifically in Montana, Dr. Running as well as Dr. Kathy Whitlock. I mean, the testimony of Dr. Whitlock about what is going on in Montana, what this was remarkable, because she, along with, we had an expert on glaciers, an expert on water, Dr. Stanford, Dr. Faegre. What we tried to do was to show so we'd have a glacier expert, and then we'd have a plaintiff who loved glaciers and was seeing, and the testimony about how the glaciers were receding and how that was affecting the water table in Montana. You then had plaintiffs who they love to hike around glaciers, or they love to fish, fly fish. I mean, that's what people do in Montana. They hunt, they fish. And we had plaintiffs who did that. And then we had experts to show how, if you're a hunter, if you're a fly fisher lover, that you're going to be affected dramatically by the climate change. And then I think a bit of testimony that really needs to be emphasized is in Juliana. We all know about Juliana. We had expert witness Gus Speth. Those of us in the climate movement know Gus, and he wrote a book, They Knew, which is in essence about what the federal government knew over time, and yet continued its efforts to get fossil fuels out of the ground. Well, we had an expert, Ann Hedges, in Montana, who talked about the history in Montana of how permits have been and are being granted, notwithstanding the known effects to the climate. As Ann testified, there's never been a permit for a fossil fuel project in Montana that's been denied. And so that all that testimony, putting it on, is extremely important for other judges who are going to sit down and figure out, well, I've got to case manage another climate case. How did Judge Seeley case manage the held trial? And it started with her pretrial order, where she set out 5 issues that she was interested in having for purposes of the trial, and then resulting in her decision, where she lays out in a very important way how the expert testimony caused her to recognize that the provisions that were at issue didn't pass scrutiny when laid aside to the Montana Constitution. And so I think one aspect of the precedential nature of this decision is it not only shows these cases can be tried, but that they can be tried effectively. Remember, it was only 7 days where we tried this case, resulting in over 100-page decision. And but they can be tried in a way that a court will understand the significance of the climate science, understand the significance of 350 parts per million versus where we are, understand the history. And that's why I think the Held decision is really going to go down in history as something that practitioners will look back on and say, that's how you try this kind of case.
Speaking of which, Phil, and this will be my last question because we have a wealth of interesting questions in the Q&A already. Let's focus on the youth piece. Of course, the public voices and the voices in the courtroom as well were to a large extent young people. Not to say you're not that young, but the other people clearly are younger. So and this, of course, has been done in other places or other jurisdictions after OCT started that wave back in the early 2010s. In fact, in just a couple of weeks, we'll be witnessing this historic hearing before the European Court of Human Rights in the Portuguese young people's case. And the question for you is, what practical factors and what strategic factors need to be taken into account in working effectively with young people as plaintiffs to highlight their voices, to feature their voices, to make sure that they also understand the science, understand the stakes, and that they remain kind of at the forefront of the case throughout?
I want to tell you a quick little story. Before we begin any big hearing, or in this case, the trial, we all get in a room, put on some fun music, and dance. And that's to make sure that we all are energized. And the energy is primarily coming from the youth over to those of us who are less youthful. Let's just call it that. And so let's walk through how the youth in cases like this really affect the case. First off, you have to decide who's going to be a plaintiff. And we go through a rigorous process of talking through what we understand each of these plaintiffs will have to go through. I mean, I don't know what you were doing when you were 14, but I was not suing my government. So what it involves is telling their stories, to go back to your term, storytelling, telling their stories for purposes of the complaint, developing their stories as the case goes along through the deposition, where they're examined by attorneys, in this case for the Attorney General's office, or in Juliana for the Department of Justice, and then getting up there and having the courage to speak truth to power by getting on the witness stand. And let me tell you that the stories our youth plaintiffs told, and the way they told them, were the most compelling parts of the trial, because they really believe not only that they should have hope, but that it's because they're engaged in action that they have hope. So anybody out there, if you are considering being involved in litigation, remember, it's a way to be active. It's a way to affect change. And when you're active, that gives you much more hope. And so when the youth were able to see witnesses testifying about what the government was doing, the youth were able to see a judge listening to them and ultimately have a judge rule in their favor, really gave them a sense that government can work. Because let's be honest, in Montana, at the federal level, it's not the legislature, it's not the executive that's really listening to them. They kind of, do one of these things, but they follow the money. Let's be clear. But the courts are not that way. The courts give youth a voice. The courts recognize that youth have rights, and the courts are prepared to when youth speak truth to power, the courts are prepared to have issue remedies that will support the youth and give them more hope. So it's going to be a building like a snowball rolling down the hill. It's really going to be building like the civil rights cases that occurred, Brown versus Board of Education being the culmination, or the gay rights cases. It's you start with smaller state cases that eventually move forward. Here, the youth and future generations are being represented in the courtroom primarily through climate scientists, excellent lawyers and support staff, but through the voices of these plaintiffs who really are courageous. And I've got to tell you, I get emotional just thinking about them.
I understand why, Phil. So that already, and this is perfect timing. I'm not surprised that your time management has been impeccable. We're getting exactly to 40 minutes past the hour, where we want to turn to our colleagues and friends' questions here. Already, your last response addressed Joey Lee's question about the place of young plaintiffs and the youth movement in this type of litigation. But I'm going to go back to the first questions that were raised, starting with Professor Doug Kaiser's comment/question. So he says, "Congratulations, Phil, to you and all your colleagues on a historic achievement. The U.S. Department of Justice quickly filed a memo in Juliana arguing that health has no bearing on the federal constitutional argument. Why do you think the Biden administration fails to see how their hand would be strengthened by a constitutional ruling in your favor?"
So first off, I don't understand why the Biden administration is doing this, except that it's following the playbook of the Trump administration, which is to keep the climate science and the youth voices out of the courtroom, to keep a judge from declaring various constitutional rights, and to keep a judge from determining that federal government conduct is violating those rights. And so I really believe that the Department of Justice, we at our Children's Trust, if you go to the website, there's ways to reach out for everybody here and your friends and people you just meet on the street and the coffee shop, to contact the Department of Justice and say, let Juliana go to trial. That's what we're asking the Department of Justice to do. And held shows our judge in Juliana, Judge Ann Aiken, it shows her that these cases can be tried, and that declaratory relief, which is what we're asking for in Juliana, is important. because now the state agencies in Montana are required to consider fossil fuel emissions. They're going to be considering the effects of Montana's actions on the climate crisis. And that's what we want Judge Aiken to hear in the courtroom in Eugene, Oregon, and what the Department of Justice and the Biden administration are scared of. They're scared that the evidence is going to come out that they're just like the Trump administration, that they're really harming our climate. And they don't want that evidence in the courtroom, because remember, you can talk about fake news all you want on TV, but fake news in the courtroom is perjury. And so that's what they're scared of. And we need to break down those walls and let Juliana go to trial.
Speaking of Judge Aiken, Doug also notes that Judges Kathy Seeley, Judge Aiken, and Josephine Staten are all have written powerful opinions agreeing with your claims. All three happen to be trial judges and women. So this is also a question that I ask myself oftentimes, and my students here, whether this is a coincidence. But we also have a number of questions having to do with the potential repercussions in Montana and outside of Montana at the state level. So why don't we take them all in one fell swoop? So what do you think are the prospects on appeal? Jessica Palaret is asking about the appeal, about any chances of the decision being overturned on appeal. And also, Kevin Colley asks whether there's any concern that the state legislature in Montana will respond with more hostile statutes.
So I'm going to take the second question first, because it's the easiest. The way Montana works is the legislature meets every 2 years for 90 days. So the next time the legislature will meet will be essentially in the first quarter of 2025. So we can make a lot of strides between now and then with the Held case in terms of constitutional law. A couple weeks ago, I received a call from the attorney for the state, and the state wanted to move the Held case quickly to the Montana Supreme Court through a process known as interlocutory appeal, where essentially the judge certifies the case as being ready to go up to the Montana Supreme Court. And by the way, Montana doesn't have an intermediate appellate court, so it's trial court, Supreme Court. We worked with the state and have now presented a motion, an unopposed motion, to Judge Seeley that's been fully briefed as of yesterday, for Judge Seeley to certify as final the Held decision so that it can be considered promptly by the Montana Supreme Court, because the Montana Supreme Court has other cases that bear on Held. But I'm going to come back to a point I made earlier, because this really, I think, will guide the Montana Supreme Court. The trial in Held presented a lot of evidence about the climate crisis, how it's affecting these young plaintiffs and Montanans generally, and what Montana could be doing instead of ignoring fossil fuel emissions and their impacts on the climate crisis. The evidence is going to be guiding the Montana Supreme Court, because they're in essence going to say, well, what evidence was there of the constitutional violation? What evidence is there that the statute doesn't pass scrutiny? And there's overwhelming evidence on this point. And the state did not introduce much evidence at all. In fact, the state's sole expert witness, Dr. Terry Anderson, if you watch the trial, was essentially on direct examination on the witness stand for like 10 minutes, answered only 3 questions about emissions in Montana, nothing that really bore on the effects on the economy, nothing that bore on the climate science, and some attorney was able to discredit Dr. Anderson, and Judge Seeley found that he had no credibility in her order. And where I'm going with all this is, any court, a Supreme Court that is prepared to exercise some level of judicial courage, will base its decision on the evidence. And the evidence in Held is overwhelmingly in favor of the plaintiffs. And Montana Supreme Court has, for decades, been remarkably protective of the Constitution and constitutional rights. So we believe, given the evidence, given the provisions of the Montana Constitution and the Supreme Court's pronounced precedents on protecting constitutional rights in Montana, that we stand an excellent chance that the Held decision will be upheld on appeal.
Thanks, Phil. I'm going to do the same with questions having to do with potential ripple effects of this decision in other jurisdictions. So one, of course, key piece of the strategy and of the legal background that had an influence on this case is the fact that the Montana Constitution does protect explicitly the right to a healthful environment. In fact, it must have been one of the first jurisdictions anywhere to have done so, because it was in the early 1970s, before there was a kind of a whole wave of adoption of the right to a healthy environment in national constitutions, let alone state constitutions in the US. And in fact, we now see a new wave of interest in using this very argument across the world because of the UN General Assembly's recognition of an international right to a healthy environment just last year. So, and there are a few other states in the US where there are some active cases going on that also have incorporated a right to a healthy environment. So do you see this particular move using the right to a healthy environment as a way to get to the more specific right to a stable climate system, or to argue climate cases, as a promising avenue in other jurisdictions?
Very much so. So first off, there are other states that, as you pointed out, have either identical provision or similar provisions. Further, there's a movement to get provisions in the constitutions of other states that will be on the ballot in upcoming elections through 2024. But also, as you point out, there's this international recognition of the right, which I think will very much help us in our international cases. The Held decision, though, shows, I'm going to call it, other judges in considering these rights-based cases, the importance of issuing a declaratory judgment. And I want to shift here very quickly to the momentum that was caused, resulting in the Brown versus Board of Education decision, because there's a lot of parallels here. In there, the NAACP was bringing cases on behalf of children, as we all know, the school district cases. And the children were being affected by the separate but equal policies, emotionally, psychologically. And those were the injuries that the Supreme Court found for purposes of the Brown case. But the Brown case worked its way up. There were smaller cases, there were state cases. And what's important here for the climate litigation movement is we're now seeing victories in the climate cases. Judges are going to get emboldened, like the judges were in the civil rights cases or the gay marriage cases, to essentially say, well, you know what? These youth have a right. The government action is creating the danger. The government is acting with deliberate indifference. And even, let me just tell you this, even if you're a conservative right-wing person in the United States, nobody wants the government knowingly harming citizens. That having judges ignore that is extremely bad precedent, no matter where you lie on the political spectrum. So we're pressing forward with those types of cases, like Justice Clarence Thomas found in his Uzak Bunham case a couple in the 2020-2021 term. You don't need a lot of damage to get into court. And once you get into court, then the judge is going to examine the evidence in light of the right. And here we have substantial rights that Judge Seeley found to have been violated: equal protection, life, liberty, etc. And those rights are going to transfer to other cases and other trials and other decisions, so that the precedents are going to start snowballing, as I said earlier.
And speaking of present and future harms, one key and not so visible repercussion of this case is having raised the bar, or sadly lowered the bar, in terms of the threshold of global warming at which we know major human rights and massive human rights violations are being perpetrated. So we don't have to wait until we hit 1.5, which is the threshold that gets talked about and that was adopted in the Paris Agreement, and that even scientists have very clearly said exactly the same thing recently in an article that we're going to post on the chat here, saying that just as there are planetary boundaries, there are justice boundaries. And even if we haven't hit the very maximum level of global warming that the Earth as a living system can take, we've definitely gone past the threshold of what human beings who are entitled to a dignified life need in terms of a stable climate system. So this adds urgency, raises the bar in terms of what needs to be done more urgently. And this is something that I personally hope that litigators will pick up on and judges will pick up on in future litigation. I'll go to the very last question on impact. So the question here from Ashley: do you think the requirement to consider emissions will have a meaningful impact in the number of permits issued? Or might we end up in a scenario where the state considers it, but still continues to grant all permits?
Well, first off, I want to talk about the 1.5, because Kelly's listening and she won't let me forget if I don't bring up that 1.5 is political based. It's not science based. And it's science that should dictate the outcomes here. And that gets me to answer your question. Judge Seeley is very clear about what needs to be done in Montana, in her opinion, which is to stop enabling fossil fuel emissions, whether in consumption or extraction or transportation. And I think it's very important that what's going to happen going forward is the state is going to be presented with let's call it an environmental impact statement, for want of a different term. And it's going to have to say all the various climate impacts, not just emissions, that are going to be caused by the project, whether it's a new project, a renewed project, whatever it is. And Judge Seeley's opinion is going to guide the state into whether or not it can approve the project, but more importantly, should the state grant the project, then Judge Seeley's opinion, and hopefully the affirmance by the Montana Supreme Court, will cause those projects not to be allowed to move forward, not to get a permit, not to get renewed, whatever the situation is, because we've put that evidence at trial. And that evidence can be reintroduced in these various matters on the projects on an administrative record to show that the state, if it didn't do its job, and I'm saying if it doesn't do its job, it doesn't fully consider the climate impacts and grants a permit anyways, which was in the question, then trial judges in Montana, trial judges in other states will not allow the permit, will not allow it to the project to move forward. And that, to me, as a practical matter, it really makes held more than just a decision we read about and then put on the shelf. It's going to keep coming up in Montana and in other states that have fossil fuel projects, because we've now got findings on the importance of shutting down these projects, of not giving them permits because of the effect they're going to have on our youth and on future generations.
Thanks, Phil. I think that that's a perfect place to end and transition to the private conversation about strategy. But I will end by saying that in law school, students are either told, in law schools in general, are either told or get the sense that things cannot change in the law, that it takes centuries, if not at least decades, for things to change. And things have changed very quickly in this space, in climate litigation, and what judges, litigants, UN agencies are willing to say about the human rights implications of climate change. Scientists are also coming out and forcefully speaking about the real suffering that people across the world, especially those in the places and countries that have contributed the least to the climate emergency and yet are suffering the worst of it. And this is all changing as we speak. OCT started only 12 years ago. It sounds like a long time, and certainly for any individual organization to keep at it for 12 years and wait for decisions is a remarkable achievement. But 12 years is very little in human history terms, let alone in geological terms. So for people who may be disaffected by the consensus or the dominant mode in human rights advocacy about the end times of human rights, about the not enough rhetoric, well, this is happening. You just have to look at the evidence. You have to see what creative litigators and organizations like OCT and Phil are doing, and spend less time diagnosing the end times and join the more creative trend of trying to make things happen. And definitely, this case is a shot in the arm in terms of giving a boost in terms of confidence and inspiration. And with that, I want to thank again OCT and Phil for creating this space and for making themselves available for this conversation. With that, thanks again for the time, and see you in next month's webinar.
Thank you all. Thank you for attending. And quickly, if you go to our Children's Trust website, if you have any questions you want to ask of me, you can get to me through then, and you'll learn more about our cases and how you can contribute.
Definitely. Thanks.